Our next speaker is Andrew Campanelli. Andrew Campanelli is a Litigation and Telecommunications Act attorney who handles local, state, and federal Telecommunications Act-based litigation. He's authored numerous local codes that provide protections for citizens while complying with all FCC requirements. And since beginning his legal career as a litigator in 1992, Mr. Campanelli has handled over 7,000 civil and criminal cases, and he's litigated over 1,000 cases to conclusion. He is at home in the courtroom, and you're about to see why. Ladies and gentlemen, Andrew Campanelli.
Thank you. Thank you. Good afternoon. Yeah, the first thing I want to tell local officials, and I tell them all the time, is that contrary to what you've otherwise been told, local governments have extremely broad authority to control not only the number, but also the placement of wireless facilities in their jurisdiction. I point out that when the Telecommunications Act was adopted back in '96, Congress actually considered giving the FCC the power to control where they go. And at the end of the day, they chose to do the opposite, and they drafted paragraph C7A, which is entitled General Authority, and within which Congress explicitly preserved to local governments the general authority to regulate the placement, siting, construction, and maintenance of wireless facilities in their jurisdictions. The two biggest things in your way are, number one, that you haven't drafted a code to grasp hold of that power to the maximum extent it was preserved to you by Congress, and number two, to the extent you have adopted a code, very often you do not encompass within that code procedural guidelines for your boards to follow to make sure that if and when you deny an application for a wireless facility, you comply with the procedural requirements imposed upon you by the Telecommunications Act. This second defect covers 99% of the cases when local governments get sued. Making things worse is very often local governments will go to their general municipal council and say, can you draft us an ordinance? That general municipal council may be brilliant. They may be great at what they do, but they know nothing about the Telecommunications Act. And the worst part occurs when they do some research and they said, I can get this. I'll read the act and I'll do some research and I'll look up case law on Westlaw and Lexis, and I've got a handle and I can say what you can and cannot do. And they end up committing malpractice on a daily basis. As we speak today, the 5G rollout is going on across the country en masse. Site developers are rolling into local governments and saying, we want to put DOS nodes every 150 feet. And the current codes are completely ill-equipped to handle these things. So why don't your local municipal attorneys know what they're doing? It's not entirely their fault. I'm going to tell you what it is. Number one, when they do their research, they don't know what to look for. Any attorney normally doing research, especially for litigation, will look on the classic research tools, which are known as Westlaw and Lexis. And what they'll find is, of all the lawsuits filed under the Telecommunications Act, local governments may lose 50, 60, 70% of the time. And they say, oh, well, our hands are tied. We can't do anything because if we do, we'll get sued. What they fail to understand is they're looking at the wrong universe. In the vast majority of cases, maybe 85%, where local governments actually know what they're doing, they will deny an application for the irresponsible placement of a wireless facility. They will do so that complies with the procedural requirements of the Telecommunications Act, and that's the end of it. There is no decision in any federal court because no lawsuit's ever brought. So in 85% of the cases when local governments use their power to prevent the unnecessary proliferation of wireless facilities or prevent the single irresponsible placement of a particular wireless facility, when they deny it the right way, that's the end of it. But municipal attorneys, when they do research, they don't find any of those cases. The other and even bigger problem is that when they read the Telecommunications Act, they don't understand that the Telecommunications Act of 1996 actually imposes procedural requirements on your local boards when they're deciding cell tower applications. But here's the kicker. It doesn't explain what those procedural requirements are. And so most local codes do not provide procedural guidance for their planning board or planning commission or zoning board of appeals, which they have to follow when they're deciding an application for a wireless facility. And when you do that, you throw your planning board to the wolves. They have no idea. They cannot comply with procedural requirements when they have no idea what they are. So a well-drafted code will, number one, set the requirements or limitations on wireless facilities. What planning districts do you let them go in? Residential districts, commercial districts, whatever. They'll set height limitations, setback requirements. They will usually also encompass legislative intent sections, which describe the types of adverse impacts you're trying to prevent, which is why you adopted a permit requirement in the first place. We want to prevent adverse aesthetic impacts, reduction in property values, make sure there's efficient, safe fall zones, things like that. Under federal law, you can treat them like any other zoning application, and your local code can give you grounds to deny the applications. The main constraints on your exercise of that power, again, are the procedural requirements. And so any denial has to be based upon substantial evidence and within the shot clock, things like that. One of the most important decisions to come down to solidify the power of local governments is the Extenet versus Flower Hill case, which was one of my cases. In that case, federal court ruled two very important things. Number one, that federal courts sitting anywhere are not bound by rulings of the FCC necessarily, within which the FCC tries to strip more power from local governments, but instead, district courts are bound by the circuit courts of appeals. And those circuit courts of appeals have set standards for proving when an effective prohibition occurs. What does that mean? Well, one of the constraints the Telecommunications Act imposes upon local governments is it says you can't deny an application if the denial would effectively prohibit an identified carrier from providing personal wireless services in your jurisdiction. Now, remember I said carrier, not site developer. That means that even if an application or a proposed installation would violate your local zoning code, you'd have to grant it anyway if the denial would effectively prohibit the provision of personal wireless services. The key is, according to the United States Courts of Appeals in virtually every circuit, applicants have to prove certain things to your board, and your board gets to decide if and whether or not they prove both of those things. Of course, if your code provides that they get to make those factual determinations. Your board also gets to decide what evidence to require the applicant to produce to prove those things, and gets to determine the weight to give any evidence that's been submitted. Most important of all, you've heard talk about a significant gap. That's one of the things they have to prove. Generally speaking, if an applicant wants to build a cell tower, they have to, and they want to claim that a denial would be an effective prohibition, they have to prove, in most cases, that an identified carrier has a significant gap in personal wireless services and that the proposed installation is the least intrusive means of remedying that gap. Well, how do they prove the existence of a significant gap? As they roll out new levels of technology and new frequencies, they try to claim that anytime they want to install a facility for a new service or to improve existing service, a denial will be a violation, and that's inconsistent with the law. In Extenet, there was a case where a site developer claimed that an identified carrier had a gap in their 5G service. And when the application was denied, they brought a federal lawsuit saying a denial was an effective prohibition. The federal court embraced an argument that I've been submitting for 30 years, that a gap in 5G service does not prove a significant gap, and a denial of that application does not constitute an effective prohibition, because the court ruled that maybe your customers can't connect on 5G, but if you've got 4G coverage, then you've got coverage. And this particular carrier provided service on 7 different frequencies. And so the court said to prove a gap in service, the carrier doesn't have to prove that it has a gap in 5G. It actually has to prove that their end use customers cannot use their phone to connect to a landline. And in the context of the 5G rollout, in 98% of the applications being filed, the applicants cannot meet that test because they've got coverage already. So with that, I'm going to cede the rest of my time in the hope that some of you are from local governments and you've always wanted to ask some questions about the Telecommunications Act and what it says you can and cannot do. And I hope you pose those questions here today and take advantage of the opportunity to have so do so. So thank you very much.